If you're an immigrant who entered the United States over 10 years ago without permission, and you're married to a U.S. citizen spouse at the current time, or if you're a United States citizen spouse married to an immigrant who entered the U.S. without permission 10 years ago, you're probably interested in the new Parole in Place program announced by President Biden on June 18, 2024. You're wondering what are going to be the final details. You've heard the initial details perhaps or read them, and you're wondering are there going to be more? Well, certainly there is going to be more to the program. The government's going to lay out probably some sub requirements that you need to know about. And some they may not lay out, but they're going to be inherent in the rules that they set forth based on past programs. Now, I don't know what the final rules will be, and I don't know anyone who does, but based on experience working in similar type cases, I think we can make some reasonable presumptions. Some of these presumptions may be off a little, but they are things that practitioners of immigration should start considering, and that those who are thinking about seeking parole in place should start also considering. I'm going to divide this presentation into three sections. I'm going to discuss various insights. I'm going to divide them into three sections. One, practical matters. These are the matters that set the parameters of the program. These are parameters that will include some people, exclude others. And so we have to know those limitations. So we're going to discuss practical matters, parameters, and limitations. Secondly, we're going to discuss the essential rules. By that, I mean the 5 requirements that the Biden administration has already mentioned. So we know those are going to be the requirements. What we don't know is what are going to be the sub requirements, what are going to be the nuances, what are going to be the details. So we're going to discuss those so that you have a better understanding of the 5 rules and what will likely be attached to them. Third, I'm going to discuss corollary matters, corollary things to know and understand that are going to be a part of the program. Some that will be good news for some applicants, and some that will be bad news to other applicants. Let's get started. The first practical matter I want to discuss is entry without admission. If someone comes through the border and the officer inspects them, authorizes them, allows them to come through, that's a legal entry. That's an admission. Parole will not cover those individuals. Parole is for those individuals who entered without permission. So that is a major distinction that has to be made right at the outset. So the reason for this program is that individuals who have entered without permission, even when they're married to U.S. citizens, often have to go back to their home country for an interview through the consular processing mechanism. And that is a complex action, and often individuals need waivers, and the waivers are complicated and costly. And for that reason, many immigrants have not gone forward with their cases, immigrant spouses of U.S. citizens. That's the main purpose of the parole program, to assist those individuals. Now, the Biden administration set forth a certain number of individuals who might qualify. I think their number is a little high because, as we'll see as we go through the different requirements, there's going to be items that may exclude a lot of individuals who would otherwise qualify. The second practical matter we want to discuss are that the official requirements are unannounced and unknown. I don't know them. None of my colleagues know them. We can make some reasonable guesses, but that's all it is, a reasonable hunch as to what more will be added to the program. And we may not hit all the items. We may miss some items. And then again, we may add some items that the government decides not to include. But the purpose of this presentation is to give you greater insight into what the program might be so that you can start thinking ahead of time as to what is your possibility of going forward with this program. You want to make sure that you're ready when the requirements hit, when they're fully announced. And at that point, some of the things that you think about in advance would help you get off to a running start. The third practical matter is that of relevant evidence. Relevant evidence, the organization and presentation of that evidence. There are two problems I see with that. One, a lot of individuals, because they want to cut costs, they go to a family member who's gone through the immigration process, or a friend, or a coworker, or a church colleague, or someone in the community. And the individual has good intentions, really wants to help them. But the parole in place program might be a little over their head. They may not be able to really present the evidence that's going to be needed. The other factor that comes into play here is that when a new immigration program comes into place, a lot of shysters open up offices. Offices spring up all over the place. Notarios, legal assistants, immigration consultants, even lawyers. And they're not prepared to deal with parole. They're not competent. And worse, there's those who are not well-meaning. They're really shysters that are going to take the money, leave someone high and dry, or just throw anything out there, hope that the immigrant believes it and submits it, and then the immigrant has a lot of problems. And that's what we don't want. The reason for this presentation is that we don't want the hopes of a better tomorrow for individuals who have been waiting a long time, many of them with kids, 2, 3, 4 kids, and a family that depends on them, to think that they're heading to success and they're really being placed on a slow boat ride to deportation. Got to be careful about that. That is why I put relevant evidence at the top of this list. It's going to require a lot of good evidence, as you'll see when we go through the requirements, and you're going to need competent help. Nobody can say, hey, I'm ready to go forward now. I can't say that because we don't know the exact rules. We may have experience that tells us what's going to come in play. What I do say is this. I've heard a lot of media channels tell people, don't go to anyone yet, don't pay any money, because the rules aren't out there yet. That's true. However, if someone in your family has gone to a lawyer that they've really, really respected, or if you or your spouse has gone through the process with a lawyer that you respect, well, consult with them ahead of time. Because some of the requirements, which we're going to get into in a minute, are things that you can start getting ready for. It doesn't mean you're presenting your case, but it means you're getting ready so that the sooner your application is ready, after it's adequately prepared, the sooner it's adequately prepared, the sooner you can submit your parole document. So why not? That's not the same thing as going to someone, giving them money and saying, hey, do all this for me. There's a difference. And again, if it's someone that you've worked with before and someone that you fully trust, then, hey, there's a track record there. That's a different story. Let's go into the second section now. What I call the essential rules. Essential because the government's announced these requirements. The first is residence 10 years in the United States. President Biden announced the program on June 18, 2024. And the first rule is that undocumented immigrants, those who came in without permission, must have 10 years of continuous residence in the U.S. as of the day before, June 17th, 2024. There's a reason for that. I often tell clients getting in line may not get you anything other than getting you in a line for a program that's yet to come on down the line, that come on board. So the reason why is that they don't want to create a program that all of a sudden people jump in just because they created the program. They're trying to help those who already qualify. And so when he announced it on June 18th, the door for applicants eligibility had already closed June 17th. That's the date they had to qualify by. So that's pretty common. So the 10 years back means June 17th, 2014. Maybe June 18th, but let's say June 17th. Those are the 10 years that someone's going to have to show continuous residence in the US. And that's going to be difficult for no other reason than the undocumented immigrant came in without authorization, without inspection. They're going to have to prove they entered on that day. It's going to be difficult. Then they're going to have to prove 10 years going forward. That's going to be difficult for a lot of individuals. And that's one of the reasons why relevant evidence is going to be crucial. Now, in some areas of law, continuous residence is okay even when someone's taking a brief, casual, and innocent departure, a break. I don't know that that's going to apply to parole here. Continuous may mean absolutely continuous, no breaks. We don't know. We're going to have to see the requirements. The other issue is some individuals may have come in legally on a visitor's visa, on a tourist visa, a student visa, and left on time, say 2012. And they came back 2013, left on time, and then the third time came in 2014, early 2014, and they never left. In that case, the legal entries I do not believe will affect the immigrant because the date of the undocumented entry, the entry without authorization, will have been the last entry. And I believe, based on case law in other areas, that the last entry will be significant. Again, that's another issue that we'll have to take a look at. Those who may have came in, say, with entry in 2013 and 2014, and then they came in without permission in 2015, no, I think they're going to be out of luck because they're not going to have the 10 years of unlawful presence in the U.S. based on their entry without inspection. The second requirement we know is marriage to a U.S. citizen before or on June 17, 2024. That means imagine a couple that they were paying attention to the news, but they didn't take everything seriously about getting in line. And so they waited to get married, say, the following Saturday, June 22nd, 2024. Well, they're going to be out of luck. That's going to be, in my mind, a strict requirement. You know, that extra 5 days, I think, boom, they're disqualified. However, I think the bigger issue is going to be that of a common law marriage. Take an immigrant, undocumented immigrant, who lived with the U.S. citizen spouse in a state that recognizes common law marriages. Well, is the government going to recognize the common law marriage as a legal marriage? In my mind, the government should, and based on case law, there's grounds for it. It may be a battle, though, to prove that. So this undocumented immigrant is going to have to prove the 12 years of living in the U.S. continuously, and now is going to have to prove a marriage that was by common law. Going back to my issue earlier, that relevant evidence is going to be very important. The third requirement that the government's talked about is good moral character. Disqualifying crimes, that the government says. I consider that a good moral character blemish. For me, the concern is, are they going to use good moral character in disqualifying crimes more or less in the same vein as they do in other areas of law, as they do for someone seeking permanent residence? Or are they going to impose a more strict standard? Take the DACA folks. For DACA folks, a disqualifying crime was a significant misdemeanor or multiple misdemeanors, no matter how nonviolent, no matter whether or not they only spent a few hours and a few days in jail and the fine was minor, they could still be disqualified. That's my concern in terms of the disqualifying crimes. If they keep it to the standard ways they have reviewed crimes in other areas of law, that's more understandable. But will they impose a more strict standard? We don't know. I don't know. But it's something to keep in mind. And it's one of those issues that if there's even any question about it, even if you have those types of minor convictions, you should seek out before you apply a consultation with an immigration attorney to find out whether or not there is a possibility that's going to be held against you. You need to know that in advance so that you avoid that slow ride to deportation court, and then maybe an order of deportation from a judge. A fourth requirement is that of national security and public safety. The government wants to be sure that the immigrants who go through the parole program are not a threat to the national security of the country or to the public safety of American citizens. Those two criteria seems pretty easy to spot, to specify. But the real danger, I think, for future applicants under the parole program has to do perhaps with activities when they were younger. Perhaps an immigrant was involved or associated with gang activities in their home country when they were younger. Or maybe if they came to the US at an early age and they associated with certain individuals. Well, those types of associations, those connections, or even being a member of a gang could be considered a threat mainly to the public safety of American citizens. And those could be considered to be disqualifying marks against the immigrant seeking parole. So that's another consideration that has to go into the pre planning of an application for parole. If the immigrant has been involved in any such activities, you want to make sure again that you talk to immigration counsel. There was a recent case where an individual wasn't allowed in the country because of tattoos. And those tattoos in the officer's mind indicated gang activity, even though in this case the tattoos presumably were not the type of typical tattoos used by gang members, but more religious tattoos. In any event, that individual was not allowed in the country. That's a recent case. We have to keep our eye out on matters like that. So if the immigrant has been involved in any type of activities or has gotten certain types of tattoos, it's going to have to be looked at. The fifth requirement we know of is discretion. What a lot of individuals don't realize is that in immigration court or any immigration benefit sought, there's a requirement of discretion. And the government has to issue a favorable judgment based on discretion, how they see it. So you take an individual and they meet all the requirements for parole. Yet the government looks at it and says, I don't know if you merit this. That could be a problem. An individual who hasn't paid child support for another relationship many years, an individual who has several years of, say, they haven't paid their back taxes or submitted their taxes, an individual who has court orders that they haven't obeyed. Those are negative factors. On the other hand, a factor such as someone that's been involved in their community and volunteers and helps, that has 2 or 3 children and has a good paying job where they have received awards. Those are factors that could be weighed in their favor. So Those are factors that would be balanced. So what the government does is they're probably going to balance this. Bad, good. And they're going to want to make sure that the good is higher than the bad to exercise favorable discretion. And again, because it's subjective, that's going to be one of those issues where the officer could make a difference. A stricter officer will look at things more carefully and strictly than one who's a more lenient officer. And because it's a discretionary call, if the matter is based on solely discretion and it's not and parole is not granted, it's going to be hard to challenge it. Okay, time for the third section. Good things to know and understand, corollary matters. The first is let's talk about the I-94. That's going to be granted if someone wins parole in place. When the individual came to the border that was inspected and authorized, they're going to get an I-94. That's the entry and departure record. And it shows when they entered and by when they have to depart. From my understanding of what's going on with the parole in place program, it's going to be a 3-year grant. I don't know. I don't think it's going to be 1 year at a time, 2 years at a time, or 1 year and then a renewal and then another year, or a year and a half and then a renewal. I think it's going to be a 3-year grant straight through. Okay, and I think the program is probably going to be 1 3-year period. That after the 3 years, parole in place is going to go poof and disappear. I could be wrong. We don't know yet. But I'm assuming that I-94 will be for 3 years. And during that 3-year period, we move to the second thing that you must know. That once the immigrant is granted parole in place, they have to apply for permanent residency. There's a permanent residency application limit. And it's been clearly stated they're talking about 3 years after they get a grant of parole that they have to have applied for permanent residence. So the person who procrastinates and says, oh, I'll wait, I'm going to save a little more money, I'll take my time, or they're assuming that the parole program may be renewed, could run into a lot of problems and lose their golden opportunity to become a permanent resident. There's also something else implied within that winning parole doesn't mean that the immigrant wins permanent residency. But there's a 3-year window once parole in place is granted that a person has to apply for permanent residency. And unless the parole program is going to be longer than 3 years and they allow individuals to renew their application, it's going to be 3 years straight out. My recommendation, of course, in either case is file for it as soon as you can. Don't wait. Once you get that grant of parole, file for permanent residency. You want to do that. The third corollary matter you have to know about is the children of immigrant spouses. The child of an immigrant spouse can be considered a stepchild of the U.S. citizen if the marriage occurred before the stepchild or the immigrant's child turned 18. So if the immigrant child was older, well, that's going to be a problem. So, you have to look at that issue very carefully, especially, let's say, those cases where the marriage is based on common law. Well, my goodness, you're going to have to win the common law case, and then you're going to have to prove, this is your child was born during that period. And so the marriage was before the child was 18. And you still got to prove the 10 years of residence. Whoa, that's a lot of work. So my point is, parole in place is not going to be that easy. Again, I could be wrong on how nuanced, how many details are going into the program. But based on other areas of case law, I believe that there's going to be a lot more to the program than was originally announced on June 18th, 2024 by the president. A fourth issue is, what if parole is denied? That's an issue that has to be carefully considered from the beginning, which is why I say you really want to talk. If you have any problems with what I mentioned already, any potential issues that you really have to talk to an attorney. Why? Because anytime an immigrant applies for a program and they're undocumented, they're here without permission, they're telling the government, I'm here and I don't have papers. So if your parole is denied, what's the government going to do? Because it's an executive action, is not really going to be an appeal. They may allow you to reapply. Now, perhaps motion to reopen or motion to reconsider because the government missed an important fact, or there was a fact that information couldn't be obtained in time, or the government made a legal error. Maybe, maybe. But will they allow a person to reapply? That's going to be a tough issue, especially if, let's say, parole is only a 3-year program and the denial comes like in the 5th year because the person waited so long to file for parole, or the backlog is so big that the government is way behind. You're gonna have to look at that. Remember that even if parole is granted, it doesn't mean that permanent residency is going to be granted. Okay, those are two different issues. And when someone applies for parole, and if it's denied, then they're going to go back to the original place where they were, which is that if they want a green card, assuming the law hasn't changed, then they're going to have to file an I-601A waiver if they're here in the United States. And they have to win that waiver. And that waiver is based on extreme hardship to the U.S. spouse. And those are very difficult and complex. And that's a big reason why there are so many individuals right now that are looking at parole, because the waiver process, the extreme hardship I-601A process is something that has frightened them. Okay, I want to give you one more point. Call it a bonus point here. What if problems happen at the permanent resident stage? Someone's granted parole. It's not a grant of permanent residency. What if the person runs into problems at the permanent residency stage? For instance, take an individual who entered the United States, say 2005, 2006, 2007. They entered without permission. They stayed here 2 years, went back. Now they came back in 2012, and that's the period they're using for parole, 2012 to 2024. Well, because they lived here unlawfully for over a year, and then they left, and then they came back. Well, they're going to run into the permanent bar, assuming that it's still in place. And given our Congress, I don't see how it's going to be removed before then, which means that what are they going to do if all of a sudden they lose the permanent residence case, the government spots as permanent bar, then USCIS, the reviewing agency, sends the case over to ICE, who then sends a notice to appear in immigration court because they want to try to deport that individual. Then there's a problem. The issue with permanent residency is that the rules for permanent residency will probably still be the rules we're dealing with right now. There probably won't be any change. So parole is only a short term, perhaps a 3-year window where a person has work authorization and they won't be deported, but they have a chance to apply for permanent residency. But if they're not going to qualify for that permanent residency because of some other issue, then is it wise to seek parole? That's an issue I can't answer. Every family, every individual, every immigrant's going to have to do it. I don't know. But that's why, given that situation, people, again, I recommend going to see an immigration expert and discuss those issues in advance. So, although I don't know what the final requirements are going to be, and I don't know how this program is going to be shaped down. And of course, I'm not even mentioning the fact that the program is probably going to be challenged by anti-immigration forces, and it may have to go through an entire court process before it's really allowed, people are really allowed to move forward and apply. And that's assuming a victory at court, should that happen. Now, I don't know that. So we don't know for sure what will happen. And by we, I mean the immigration attorneys. But we do know this, it's going to be a lot more complex than what appears at the time of Biden's notice. The essential rules seem pretty easy, but there's going to be a lot more to it. Exactly what, it's hard to say. But I hope that by outlining these factors, I've given you some insights into what to think about ahead of time, and even to consult with someone ahead of time if you think some of these factors may affect you. And certainly, you could start organizing certain information. How are you going to prove the 10 years of residence? You know, your marriage should be rather easy, but if you're in a common law state, you have any criminal convictions, you want to get all that looked at. You have past due taxes, you want to get all that looked at. You can start looking at that in advance. And that's a wise idea, especially because you're going to have a short window to apply. And I would assume most individuals are going to want their permanent residency, their employment authorization as soon as possible, and as a result, also their permanent residency as quickly thereafter. So with that, I'm going to wish each and every one of you the best of luck going forward. I do caution you to be careful going forward. And in wishing all of you the best of luck, I hope that should you win parole and you win permanent residence, that ultimately you go the final step to become a citizen someday. With that, I'm going to sign off. Good luck. Have a good day. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below, or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time, and hopefully we'll be talking again very, very soon.